students and they paid me $12 an hour in 1966 to teach 6 hours every Friday. Anyhow, I appreciate being invited to speak today, and I appreciate being invited to speak on such an important topic. And initially, I'm going to come from a different direction. First of all, from my perspective, educating children is basically educating children on their basic human rights. And there is an expression that I'm going to come back to: children should be seen and not heard. And again, I'm going to come back to that. The reality is that children, as we will see, who are suspended and expelled or perhaps transferred, are at risk. Any minor infraction can become a forfeiture of education and an opportunity which often results in behaviors that lead to jail. So you can have a situation where two kids are fighting in the hall. And what do you do with that situation? You come upon two kids fighting in the hall, two students fighting in the hall. What do you do with that situation? Do you suspend them? Do you call the police and have them charged with assault? Do you give them an in-school suspension? So there's so many. Do you suggest counseling for the students? So there's so many possibilities in one set of facts. But I think the most important thing that one of the most important things, hopefully, that you'll hear, and when you think about it, is as a teacher and an administrator, your greatest power bar none, is the power of discretion. The power of discretion. What do I do with a specific situation? So again, what my philosophy has always been since day one is we spend so much time focusing on the needs of adults rather than focusing on the needs of children. And many of my initial comments many of my comments are going to be focusing on kids, focusing on children. Children are individuals. They are distinct from their parents. They're distinct from their guardians. They have separate interests and separate needs. And often we forget about this. You know, what does the parent want? We're going to set up, I still remember the present provincial government, the first thing, we're going to set up a parent hotline so that the parent can communicate with us about what they want and what they need. Can you imagine setting up a hotline for kids? Is it that novel? In any event. So we have to focus on things such as nonviolent conduct. And the reality that nonviolent conduct can be resolved in a classroom, not in a police station. And with educational continuity can break that cycle of school to prison. And I still recall sitting in youth court and sitting in family court, but in youth court in particular in Scarborough, this would have been in the 90s. And as a judge, you know, a young person would be charged with a crime. And of course, as you may know or may not know, If you're a young person, you have to be 12 years of age, and it's 12 to 18, whatever. And in every case, I would always want to see a student's OSR, bar none. I want to see that student's OSR because I knew. And it turned out to be 99% correct. The relationship between being in school and criminal behavior. And in each and every case, these kids, when you looked at the OSRs, which I, as a judge, had a right to do, their attendance, never mind attendance, most of them weren't even in school at all, was atrocious. And that connection. So, you know, I never dealt with a kid that was in school every day. So it's about educating children. It's about educating children about their basic human rights. And it's about giving a voice, in my respectful belief, giving a voice to kids, taking their perceptions into account. Because if you take what they think, what they believe, what they are interested in into account now, then when they become adults, they will pass that empowerment, and that's what it is, an empowerment to their own children. So I look at it as providing kids with a voice and a ladder of participation. A ladder of participation, not manipulation and not tokenism. Participation and not manipulation and not tokenism. And Mahatma Gandhi had an incredible saying: whatever you do for me, whatever you do for me, but without me, you do against me. Whatever you do for me, but without me, you do against me. And I look, for example, at the regulation, and we're not going to go into it now, on school councils. School councils. And school councils provide for one pupil in a school, and presumably this is a secondary school. In the case of a school with one or more secondary school grades, one pupil enrolled in the school who is appointed by the student council, or if the school doesn't have a student council, et cetera, et cetera. I'm not getting into the, but can you imagine having a school council with more than one student representing the students of the school, communicating to the school council, this is what we're interested in, this is what we need, this is what, not what we want, but a voice to kids. And why does it have to be secondary school? Why does it have to be secondary school? I'm 12, I'm 13, I'm 14, I'm in elementary school. I could be charged with murder at age 12, but I can't be a part of a school council. I mean, think about it. And I was going to come to this later, but just think about it, about some of the schools in Ontario, and perhaps they're not there anymore. School resource officers, police officers, in one of my articles, I strongly oppose personally school resource officers. But think about this. How many schools that had a school resource officer did not have a social worker or a psychologist? Think about it. What's more important, a school resource officer, a police officer in a school, or a psychologist or social worker? And, you know, there's the golden rule, treat others the way you want to be treated. That's the golden rule, treat others the way you want to be treated. But there's also what I would describe as a platinum rule. And what is the platinum rule? Treat others the way they want to be treated. And children deserve platinum. Treat others the way they want to be treated. We spend so much time substituting our judgment for others. So to me, it's more involving young people. I still remember walking into the law library at the University of Toronto. This is years and years ago. And the librarian had a sign on her desk, please disturb, please disturb. Can you imagine walking into the principal's office or having when was the last time you saw a teacher with a sign or anybody with a sign saying, please disturb? I want you to disturb me. I want you to tell me what you need, what you want. In terms of suspension, in terms of expulsion, we have to understand, and whether this is addressed in Teachers College, I don't know, but understand about the children's chronological age and understanding. Children's chronological age and understanding. Children between 4 and 6 in terms of trauma reactions in schools. Kids between 6 and 12 in terms of friendship. And the biggest group, of course, between 12 and 18 are the adolescents who are reflected by physical change, emotional development. So you've got physical change, you have emotional development, you have peer groups. In other words, voices to be heard. So one of the things that I think is so important is in terms of suspension and expulsion and involving the police, as we'll come to, is we do not want to criminalize childhood and adolescence. The criminalization of childhood and adolescence has historically affected the most vulnerable of our population. There's no question about that. Studies show that. I saw it. When I was sitting again in youth court in the 90s in particular, and then transferred to a different court, it was obvious to me that there was a huge, not only two things. One, a huge disproportionate percentage of visible minorities who were charged with crimes between 12 and 18. Huge disproportionate, but even more particular, and I raised this 30 years ago. So I dealt with a young person, I dealt with a visible minority. Again, a huge proportion of over proportion. And then I looked to see, I was curious, what schools do these kids go to? In literally each and every case, they were in a vocational school. These young people, presumably, and correct me if I'm wrong, and I don't think I am, if they were behavioral problems, perhaps suspended in elementary school, then they would have been dumped, literally dumped, in vocational schools at the secondary level. So you had this vocational school, that vocational school. So certainly a disproportionate number of kids, and it raises a lot of issues. And we know that young people who do not graduate are more likely to be arrested and get into criminal behavior than those who do graduate. It was a beginning, finally, not that many years ago, that some of you may not be aware of, that Bill 52 extended education from age 16 to 18. Now, the next thing the government should do, it took them long enough to do that, and don't hold your breath, is, as some of you may or may not be aware, junior kindergarten and senior kindergarten are not compulsory. They're not compulsory. It took long enough to bring in junior kindergarten. It took long enough to bring in senior kindergarten, but junior kindergarten in particular. But the reality is that because of COVID-19, the differential, in my opinion, between the haves and have-nots is even greater today than it's ever been. So to me, a step in the right direction was when your child reaches 4, education is compulsory and they should be in school, because a lot of these kids, if they're held back, it's going to be at their disadvantage. Now, just a brief overview before we get into the slides, but the issue of suspensions under the Education Act. And by the way, if some of you, I don't know if you take law at Teachers College or not towards your degree, but all of the laws that I talk about, and virtually all the laws, period, can be found on the CanLII website, CANLII.ca. So if I refer today to the Education Act of Ontario, you just click on Ontario, click on E for education, and you got the Education Act of Ontario. So the CanLII.ca website gives you virtually all the laws and cases throughout the country. So we've got, under the Education Act, we've got Part 13 of the Education Act that deals with suspensions and expulsions. When must I suspend? And when must I consider to suspend? Two different scenarios. There are certain requirements, and we'll come to that in the in the slides. There's a section of the Education Act, it's 306, 310, where you must suspend. And by the way, it's the principal that suspends. The government, when they brought in the Safe Schools Act in 2000, there was the right of a teacher could suspend for up to 1 day. This is no longer on the books. So suspension and expulsion comes from the principal. The teacher obviously can recommend to the principal, I think this student should be suspended for whatever reason. But the ultimate decision, of course, theoretically at least, is made by the principal. He or she may consult with the superintendent, but the principal is the one that suspends. It is the principal is the one that recommends expulsion. It's the principal that decides suspension towards expulsion. It's the principal that decides I may want to transfer this kid to another school, or I may want to exclude this student from our school. But that's the role of the principal. And of course, the role of the principal, again, under the Education Act, the health and safety and welfare of the school is part of the responsibilities of the principal under Section 298 of the Education Act. Now, in terms of discretion, again, it's not mandatory, but again, providing you with an overview. But in terms of discretion, one of the things, there was a study in 2021, National Indicators of Well-Being. And they talk about, with young people, cigarette smoking, alcohol use. I just saw something in one of the papers in Toronto today about some high school, I think it's a high school in Toronto, that the kids have nothing better to do than vaping in the washrooms or something. You know, what do you do with these kinds of situations? You know, again, cigarette smoking, alcohol use, illegal use of drugs, MDMA, whatever. In Ontario, I know and again, I stand to be corrected, legislation provides that, I mean, we know that possession of marijuana has been legalized in Canada. But some of you may not know or realize that theoretically, if you are 19 or older, not theoretically, you can smoke marijuana, but for some reason, which is beyond me, as so many other things are, the legislation in Ontario says you can smoke marijuana 20 meters from a school. 20 meters. Forget about drug-free zones. I mean, come on, 20 meters. So if you're 19, just go 20 meters. What's that, 20 yards? A little more than 20 yards. Well, some of you may not know what a yard is, but 20 meters, you can smoke. I mean, come on, you know, why make it easy? It's easy enough. Every other store sells marijuana. It's why do we have to make it easier, you know? So these are things to consider. And again, these are optional, you know. Do you suspend somebody for smoking when they're underage, or again, alcohol use, or illegal drug use? Where you get into more serious areas that may not be criminal, and this is important. Do I suspend, forgetting about expulsion for a moment, do I suspend someone for non-criminal behavior? Or do I say, well, mandatory suspension is usually criminal law related? And this is a very important area, and hopefully I'll come to it, because we're now moving into the area of social media and what kids post in terms of social media. But one area that I consider very, very serious, that may, in quotation marks, not be criminal, but may be criminal, is bullying. And bullying is something that has to be addressed in a school. And St. Michael's College, which is a private and or independent school in Toronto, had considerable notoriety because of a hazing incident. And a couple of kids or somebody were put on probation a couple of days ago with respect to hazing at St. Michael's College. The reality is that if we are bullied, often this is something that we never forget. How many of us remember somebody calling us a name when we were 8 or 10 or 12 or 14, or picked on us? And how many of us have never forgot what happened or what somebody said? So you can imagine with hazing, which arguably may be a form of bullying, how that compounds what happens to kids. Now, I'll get into a little bit as we go along later about conflict resolution and peer mediation, but I want to talk about that briefly with respect to bullying. In my opinion, and forget about anybody minimizing it, bullying is not a conflict. Bullying is not a conflict. It is a form of victimization. Let's not forget it. It is victimization. It's like child abuse. It's like domestic violence. When I dealt with child abuse and when I dealt with domestic violence, it is victimization. It took us long enough in Ontario under the Education Act to give a voice when kids are suspended and or perhaps expelled. Give a voice to the victim. We are so preoccupied with the person who is the offender that we forget about the victim. Why? I don't know. So bullying is victimization, and when I was preparing for today, I said, what message do we give to the young person that's being bullied? And what message do we give to the bully? So this is what I would say to the child who is bullied. No one deserves to be bullied. No one deserves to be bullied. And we will do everything we can to stop it. And that is a responsibility, of course, of the school. No one deserves to be bullied, and we will do everything we can to stop it. And what do you say to the bully? Your behavior is inappropriate. Your behavior is inappropriate, and you must stop it. And quite frankly, in my opinion, this is the kind of situation, bullying, where mediation may not be appropriate. Because so many people do not want to face the person that bullied them. When I dealt with issues in criminal court involving child abuse or domestic violence, the child was always in a separate room from the trial. And the victim of domestic violence, there was always a screen to protect them. And the Criminal Code of Canada provides for these protections. So it's too uncomfortable. I don't, in most cases, there are exceptions. I had a sexual assault case where involving two graduate students from York University in 2016, where the person that was assaulted wanted her name to be known, which she could choose, and didn't want to screen. She wanted to face her accuser, the person she was accusing. But that's an exception, and we're dealing with people in their 20s. So in all of what I'm saying, which I think is important, is we have to change the school culture. And that's, I think, what I'm trying to say. Change the school culture. Having an assembly every so often is not going to change any culture. That's not going to change any culture. And quite frankly, and I say this respectfully, it's not about changing the child when it comes to perception of suspension and expulsion. It's not about changing the child. It's about changing the teacher. It's about changing the principal. If you exclude kids from in a disciplinary context, what you're doing is often reinforcing antisocial behavior. So discipline must be moderately strict. It must be consistently applied and perceived by students as being fair. And this is where the student voice comes in. I can't even begin to understand how somebody can be an administrator in a school without hearing the voice of the student. I can't understand it. How you cannot involve students. And if it means changing the structure of student councils, school councils, then the government should do it. And they should have already done it. Have a couple more, have another student, have two students on a school council. Have students subcommittees and students make representations. Every student council meeting, there may be only 4 a year, which is ridiculous. We're having a school council meeting 4 times a year. We want to know what you're interested in. You being the student, what are we doing right? What are we doing wrong? So the key is the school culture. Anonymity, not an issue. So again, as I've said, each suspension in the studies show that each time a student is suspended, the second time, the third time, the fourth time, their likelihood of graduating becomes less and less and less. Another crucial point to keep in mind is that the right to suspend, as I've said, comes under the Education Act. The ability of a principal or administrator to suspend a pupil. And again, I'm talking about the public school system. The separate schools, of course, are not, as you may or may not know, are 500% not regulated. The only part that's regulated is under Section 16 of the Education Act in terms of inspection, presumably at the secondary school level from an academic perspective. Private schools are not regulated. So my basic comments are the public school system or separate school system. So the authority to suspend and or expel comes from the Education Act and the regulations under the Education Act, not what the police do or the Crown does or the courts choose to do. The ability to suspend and or expel again comes from the Education Act, whether it's the act itself, whether it's a code of behavior, whether it's a school board policy. That's where the authority comes from in terms of school discipline. Some school boards, and you may have them in Ottawa as well as other parts of Ontario, but many school boards, such as in Toronto, have a Toronto Police protocol. So there's a document, a protocol between the police and, say, the Toronto District School Board. And the protocol sets out when the police should be notified with respect to what a pupil has done. In most cases, that sort of marries up with mandatory suspension. A young person being charged with a crime, a young person has done something, it's a crime, the police are involved, they may arrest the pupil, but it may be the kind of thing that you are required because of the protocol to notify the police. What's interesting is there is no duty in law, that might surprise you, there's no duty in law to report a crime. I'm not talking about, I think, certain federal crimes like treason, but there's no duty in law to report a crime. In other words, each and every time a student does something that could be a crime, somebody comes to your office, Johnny stole Jimmy's coat. So that's a theft. That's a crime. Are you going to call the police for that? Interestingly, when the Youth Criminal Justice Act became law, April the 1st, 2003, the government got rid of a lot of these property offenses because kids were getting arrested about 55% of the time for property. Is that something you would call the police if somebody steals somebody else's jacket? So again, it's, do I report it to the police? Do I not report it to the police? And that is not the ability to suspend or in-school suspension or involving parents or counseling or mediation or restorative justice. All of these things can come into play theoretically without calling the police. What are the police going to do? Probably nothing. So again, the power of discretion and perhaps experience about what you're going to do. Obviously, there are things that require notifying the police, and there are things that have to be addressed, and there are things that should be addressed. There was a court case just a couple of months ago, actually, before the Ontario Labor Relations Board involving a school board actually in Ottawa. And it must be I think it's a French high school, and my French is regrettably, I haven't spent much time in Quebec, so it's not the top of the schedule. Anyhow, what's interesting about this, this is an application in August, July and August of 2021. Le Conseil des Écoles Publiques. Anybody know what that is? Well, you can't respond anyway, but that, whatever it is, it's not English. But so this was an application, the application to the Ontario Labor Relations Board by school council members of a high school in Ottawa a couple months ago. So from the application, it appears that the applicants are parents who are not employed by the school itself. So forget about that technicality, that's another issue. The application by the parents alleges that the school engaged in various reprisals against the applicants, those are parents, after they raised concerns over the health and safety of students. After the reprisals, the applicants state they were temporarily suspended from the council. Now, I don't know whether this is true or not true, but it's ridiculous. So we've got a mechanism like a school council where you are supposed to or should be able to bring issues of the school and of the needs of kids and what is happening, what isn't happening to the school council. Who ever heard in their right mind, and sometimes people don't have a right mind, of suspending a member of a school council because they raise concerns about health and safety of students? I mean, it's absolutely ridiculous. In any event, as I tell my own students at OISE, thank God I'm not opinionated. Anyhow, so getting back to that important point, there is no theoretical duty to report a crime. There are duties to report mandatory suspension. Again, Part 13 of the Education Act. If you go to the Canley website, the section, it's, you know, in the, you'll see if we got time from the slides, mandatory, you know, such as assaults or sexual assaults or assault where someone is hurt. And in terms of mandatory suspension, it may lead to expulsion. But keep in mind that even though there may not be mandatory reporting to the police of every crime, theoretically, there are certain other obligations under the Education Act in terms of reporting obligations. If you suspend, as you know, if you suspend or expel a student, or may know, if you suspend a student, you have to set out the reasons, and I talk about that in the slides. You have to set out the reasons why this student is being suspended, and of course, provide it to the parents, because they may appeal the suspension. Now, what's important is they changed the law some years ago. If a student is suspended for 2 days, 4 days, 6 days, 8 days, and a parent appeals, my kid's suspended today, I appeal tomorrow, the appeal does not end the suspension. The suspension will continue. So in a hypothetical sense, by the time the appeal of the suspension is heard, the suspension is over. So you might say, well, what's the point of it? Well, the point of it is that suspension may theoretically be referred to in a student's OSR, Ontario School Record. So if the parent does appeal and they're successful, then they can go to the administration and say, I want that suspension removed from the OSR, which is very significant. Because quite frankly, if some of you as teachers or student teachers walk in, you know, are dealing, you're doing a practicum or whatever, and you're curious about a student in the class that you're doing your practicum, and you say to the teacher, because normally, as you know, student records, the OSR is confidential. I'm curious about this particular student. Can I see their OSR? Oh, sure, you can see well, you look at their OSR and you see that they've had a history of being a troublemaker. Is your mind already set against that student? Do we have a mindset if we know somebody is a troublemaker because we've seen their OSR? Maybe they're transferred from a different school. Maybe they've come from the public or private system to the public system. So it's quite significant what is in an OSR, and the parent certainly has a right under the legislation in the OSR to apply to have something removed, or things may be removed each and every year. Again, appreciation of the student as a victim in terms of deciding whether I'm going to suspend or expelled. And not only the student as a victim, but the impact of trauma on that student. A few of the students that were involved with the hazing incident at St. Michael's College were put on probation for 2 years. And as I mentioned earlier this morning, the trauma, the impact of hazing, the impact of bullying on young people or anybody will far, far exceed the 2 years, far beyond the 2 years that these kids have been put on probation. But again, we don't want to criminalize survivors. If students seek to, when I was a school principal, I suggested my staff this, okay, thank you. The other thing, of course, is, as some of you may be aware, because of COVID-19, statistics seem to suggest that violence is increasing in some of the schools. More young people, the Centers for Disease Control are ending up in emergency rooms, mental health issues, and students' aggression has been a reflection of the fact that schools were closed and have been closed for a very long period of time. So this is something to be aware of. The most important factor at the end of the day, in my opinion, is the teacher. And the success of a pupil often is the teacher. And arguably, talent is universal. Talent is universal. Talent is anywhere and everywhere, but opportunity is not. Opportunity is not universal. And we know this, and we know from the gap, that's the growth in the gap because of COVID-19. Our greatest untapped resource is the potential of young people. If we spend more time, better investments in human capital, we're going to all be better off. So let me spend a bit of time talking, and maybe if we can come back to the right at the beginning, Alpha, of the outline of the presentation and the so this was an outline. Legislation, the Education Act in particular, and the regulations under the Education Act, the PPMs, the right to transfer, suspend, expel pupils. So let's go to the next session. The question was asked, can they get copies of the slides? Can everybody, will that be available to everybody?
Yeah, I can put it in the chat, and it will also be available on our website, so equitableleadershipnetwork.com.
Okay, great, thank you. So, okay, yeah, thanks. So, again, there's a decision to make to suspend I mentioned this, detailing why kids suspension, and also letters setting this out, and also the right to appeal. So let's go to the next slide. Yeah. So the Education Act, and again, if you click on those blue, I think you'll get the act if you click them on. Activities for which a principal may suspend. So here's a discretion, but does not have to suspend. So again, you go to the Education Act under the Canley.ca website, and you look at Part 13, which is at the end of the Education Act. What a principal may suspend, but does not have to be suspended. All the principal has to do is consider whether to suspend. And we'll come to this, I think, but there are mitigating factors as to whether I should suspend a student or not. And that's under one of the regulations. But so, and then the regulation, we'll come to that hopefully, and if not, I'll mention it. But so you've got activities, again, may suspend, and then activities for which a principal must suspend. And again, so this sets out certain activities that a principal must suspend. It may or may not have led to a criminal charge, and most likely it would have led to notifying the police. The police, through the Crown, may decide to charge somebody. They may decide not to charge somebody. My opinion as a generalization is, and this is something else, is aside from the issues that I've talked about suspension and expulsion, and I may or may not even include bullying in this category, I would be reluctant to notify the police with respect to something that is not a crime. Because I remember many years ago at St. Michael's Choir School, a young person was involved in the school yearbook, and they transposed naked bodies of teachers over the face of a teacher. The principal called the police came to the school and literally chewed out, if I can use that expression, a young person for what happened. And 2 days later, this young person committed suicide. So I just don't see the purpose. There's a question, could you please repost the link to the slides?
Yeah, I'll be doing that after the presentation because I
Okay,
don't have
thank you.
access
So
to the
let's
chat.
move to let's go to the next slide. Yeah, this is what I mentioned earlier. Police school boards. So often police and school boards have protocols, as I mentioned earlier. Among considerations, there can be mitigating factors for suspension and evidence. You know, the kid that's bullied, you know, somebody's being bullied, you know, called names, racial slurs, and he takes, you know, and smashes another kid in the face, you know, because of how he's bullied. Is that something you involve the police? Is that something that you would suspend the pupil that hit the one that bullied him or her? The issue of special needs, and keep that, this is very interesting and very significant because a child may have been identified, there may have been an IPRC, so the child's been identified and he or she has acted out as a result of being identified in a certain way with respect to the IPRC. And the court has said if a child acts out and the teacher or the principal says, well, I want to get rid of this kid or transfer this kid, or I want to suspend the kid as a result of the IPRC or something that happened because he or she has special needs, the courts have said you have to have another IPRC. You have to have another IPRC. So you can't simply suspend or expel a special needs child. There's other factors that have to be taken into consideration. Yeah, maybe we can move to the next slide. Oh, sorry. Let me just, okay, yeah. The police school board protocols, there's some things in the one in Toronto certainly is from 2011 and should be updated. It hasn't been updated. Keep in mind, a child under 12 cannot be charged with a crime in this country. A child under the age of 12 may be a child in need of protection, such as which would require notifying the Children's Aid Society, because there's a duty to report when the child has been harmed or is at risk of harm, self-harm or harming other individuals. So if a child, you know, has acted out and committed something serious that would otherwise be a crime if he or she is under 12, then certainly with respect, it's something that I would, if I were the principal, I would be notifying the Children's Aid, well, the teacher. If the kid acts out in class, it's the teacher's obligation under Section 125 of the Child, Youth, and Family Services Act to notify Children's Aid or Catholic Children's Aid or whatever. I mean, you know, I had cases in family court where kids were acting out sexually at a very, very young age, and you know, so there's something going on there. Yeah, okay, thank you. Next slide. Yeah, that's profiling again. Something that, you know, I don't know in terms of profiling. You can't. Let me just refer to something that I think yeah, there was a case, a major case in Canada in 2003 about profiling. Do you stop somebody? Do you suspend somebody because of the color of their skin? Because statistically, this is what happens. So, but this is what the court said. Is there an apprehension? Are we biased because of someone we see? You know, the kids that, the young person that drives to your school, if they're old enough to drive and drives an expensive car, are you thinking because of who they are, how can they afford a car like that? So what the court said is, in terms of bias and prejudice,
there is also a piece related to coagulation.
Whether a reasonable person fully informed of the facts would conclude that the decision maker, whether consciously or subconsciously, was biased. So, you know, am I suspending someone simply because of the way they look? Yeah, next one, please. Yeah, so PPM, again, take a look at the Provincial Policy Memorandum 144 and 145. That's on the Ministry of Education website, which you can Google or find very easily. As you know, and one of my articles at the end of the slides talks about the government decided, I think not that long ago, probably last year, that suspensions, you can't suspend kids up to the end of grade 3. Great idea. Some of the American jurisdictions, you can't suspend until grade 6. Okay, forget that for a moment. But then the PPM, I think it's the PPM, I get confused between PPMs and regulation, but the PPM then says, starting in 2023, we're going to keep statistics, starting in 2023. And as I wrote in my article, one of the articles, if I was in charge, I want to know, there's the posting of the slides, I want to know now who is suspended up to grade 3 in this province. Are they all visible minority? And if they are, let's address it. Let's address it. How can you address any issue of racism or racial profiling or special needs kids that are suspended and expelled? How can you address anything, anywhere, without knowing the statistics? You know, if you look at the New York City every year in the New York Times, every year they publish the results of how kids do in school, grade 3 or grade 6 or grade 9. Are we a rocket scientist? So they have a column. We don't keep these columns. We don't care about these columns. We should, but we don't. We don't care about what is the columns? This one column that I look at every year. Free lunches. Free lunches. And the higher the percentage of kids that are provided free lunches because they can't afford to buy a lunch, those kids do poorer in school. Let me give you another example. Where's legislation in Ontario? And if there is some, maybe I've missed it. Do we ever talk about homeless children? Do we ever make provisions for homeless children? Have any of you ever worked in a school that you're aware of that is a homeless child? What are we doing? Yeah, next slide, please. Yeah, again, what I talked about before, you know, we got rid of most of virtually all the, thank goodness for that, the zero tolerance policies that were in place, I guess, around 2000, and which were the most ridiculous thing. That's right. The suspension is quick and dirty. It doesn't deal with whether the student's having problems at home or mental health issues. Kids are complex, and we should grant them the same grace as we grant adults. Yeah, next, sorry, next. Yeah, this is another thing. I'm not sure if we've outlawed it, but don't use restraints, for goodness sakes. In terms of restraining kids, you know, tying them up or doing this or doing, you know, putting them in rooms for hours and hours and hours. I mean, it's just ludicrous. Total lack of knowledge of what's going on. And I give you some examples here. Next one, please. Yeah, the civil rights, the UCLA civil rights, lost opportunities. Lost opportunities because kids lose the opportunity, you know, if maybe it's a semester school and it's a semester school and kids are suspended. I mean, taking this, you know, it's a short leap from being suspended to and being expelled to quitting, just quitting school. We don't want, you know, they took long enough to extend it to grade 13, from 16 to 18, Bill 52. We want to keep kids in school. Okay, next slide, please. Yeah, we'll go to the next one. Yeah, so again, we talk about restorative justice practice, which will work in a lot of situations, depending on what they are, where, you know, bring the parents in, bring the families in, and depending on what it is, you know, bullies should know how they made you feel. Again, depending on the situation, but again, we don't want to exacerbate the issue of trauma. Okay, next, please. Okay, we'll keep going because they could read those. Yeah, the protocol. Okay, keep going.
I think that's.
Is that it? Oh, yeah.
Yep.
The articles that, my recent articles are these, they can click on all of them to read them. That's great. So we have a bit of time. I think we've got 5 or 10 minutes left. I do want to finish off by quoting actually Alex Haley, who wrote the book Roots 45 years ago. I think in 1976, the book Roots came out. And he talks about continuities, consequences, and how people perpetuate themselves. And the book Roots suggests how each of us cannot but be a vehicle of the history that produced us. We are a product of our history. So he talks about we cannot but be the vehicle of the history that produced us. So he says we've got two choices: perish in the vehicle or move up the road.